When I was in junior high and high school, women and girls in Iowa were just gaining new universal rights to play sports in school. Unbeknownst to me, many of the decisions being made in Iowa and nationally governing girls and women's sports were being made because of court rulings. Indeed, as a teenager on the freshman basketball team, I was a guard. At that time, it meant I had to stop at the half-court line and pass the ball to my more gifted teammates on the other side of the court, the forwards, who made all the baskets. At the time, the commonly accepted thinking was that girls were not well suited to playing 5-on-5 because we weren't able to keep up with the demands of the faster-paced game. Thanks to a lawsuit in 1983, girls 5-on-5 basketball in Iowa came into being, and now our powerhouse female athletes are playing at the top of their game. I didn't know until this year how this right was gained. It wasn't because some nice athletic director said, "Let's do this," or some forward-thinking politician said, "Let's make this equal for girls." Nope, it was the courts. By imposing this wholesale ban on trans girls and trans women from participating in athletics consistent with their gender identity, this bill would force schools to violate both the U.S. Constitution and both Title VII and Title IX. The Iowa Association of School Boards told us directly and clearly in our subcommittee that this bill will force schools to choose between state law and federal law. There will be lawsuits, and Iowa taxpayers will be on the hook for the costs and payouts for going against federal law. This bill would require the Attorney General's office to provide representation to over 500 public and private school districts, as well as employees, administrators, board of director members, and other leadership in the event the school district or accredited private school or any of the individuals listed above is party to a lawsuit involving compliance with this bill. In recent years, presidential administrations, Congress, states, and federal courts have weighed in on this issue. School athletics must not only take into account the guidelines and bylaws of the NCAA, but must consider federal guidance of the Department of Justice and the Department of Education. So let's talk a minute about the NCAA, since college sports is included in this bill. The NCAA has had a trans inclusion policy in place for years, predating the current legal debate. The NCAA bylaws allow for transgender athletes to participate on teams that conform with their gender identity. Additionally, in August 2011, that was 11 years ago, the NCAA issued guidelines on trans-inclusive policies for intercollegiate athletic teams. The guidelines' purpose was to provide guidance to NCAA athletic programs about how to ensure transgender student athletes fair, respectful, and legal access to collegiate sports teams based on current medical and legal knowledge. The NCAA guidelines, among other things, advise institutions that all members of the school community should receive information about transgender identities, non-discrimination policies, use of pronouns and chosen names, and expectations for creating a respectful school and team climate for all students, including transgender students. Further, they recommend that transgender athletes be afforded access to locker rooms and other facilities in accordance with their gender identity, and that student athletes should be assigned to hotel rooms according to their identified gender in the same manner that other members of the team are assigned rooms. The NCAA guidelines' purpose is to treat transgender athletes the same way as their cisgender teammates. The NCAA recently reaffirmed its trans-inclusive policies, partly in response to ongoing legal battles, and stated that it regularly assesses its practices related to transgender participation and solicits feedback not only from medical community experts and inclusion thought leaders, but also current and former student athletes. The federal law has been evolving on this through some court cases. Title 7 and 9 protect against sex discrimination. Until recently, however, the scope of that protection to gay and transgender people was uncertain, as court decisions were mixed and the Trump administration did not include gay and transgender persons within the scope of sex discrimination under federal law. In June 2020, the United States Supreme Court clarified that homosexual and transgender individuals are entitled to the protections of Title VII. In an affirmance of the Supreme Court's Bostock decision on his first day in office, President Biden issued an executive order entitled Preventing and Combating Discrimination Based on Gender Identity or Sexual Orientation. The executive order asserts that all persons should receive equal treatment under the law without regard to their gender identity or sexual orientation, including that children should be able to learn without worrying about whether they will be denied access to the restroom, locker room, or school sports. This executive order changed the federal government's position on transgender rights from that which existed under the Trump administration. Since January 21st, 2021, the Department of Justice's Civil Rights Division issued a memo to all federal agencies extending the protection to gay people and transgender people under Title IX as well. The Civil Rights Division wrote that based on the Bostock decision, Title IX should also be read as protecting the status of gay and transgender students. In its memo, the division wrote, after considering the text of Title IX, Supreme Court case law, and developing jurisprudence in this area, the division has determined that the best reading of Title IX's prohibition on the discrimination on the basis of sex is that it includes discrimination on the basis of gender identity and sexual orientation. On April 6, 2021, the Department of Education's Office for Civil Rights, which is responsible for enforcing Title IX, announced it would undertake a comprehensive review of its Title IX regulations. It announced that all students should be guaranteed an educational environment free from discrimination on the basis of sex, including discrimination in the form of sexual harassment, which encompasses sexual violence, and including discrimination on the basis of sexual orientation or gender identity. On June 16, 2021, the Office for Civil Rights issued a notice of interpretation which states that the Department of Education interprets Title IX's prohibition on discrimination to include discrimination on the basis of sexual orientation and gender identity, based on the interpretation of the Supreme Court's decision in Bostock. The Office for Civil Rights concluded that such interpretation is most consistent with the purpose of Title IX, which is to ensure equal opportunity and to protect individuals from the harms of sex discrimination. In Bostock, the Supreme Court held that homosexual and transgender individuals are protected class under Title VII. Bostock came to the court as a consolidation of 3 Title VII appeals, 2 cases of which involved employees being fired for being gay, and the third involving the firing of an employee who intended to undergo gender-affirming surgery. In a 6-3 ruling, the Supreme Court found that homosexual and transgender individuals were afforded protected class under Title VII. It found that the employer's conduct constituted illegal discrimination. The majority, analyzing Title VII's language that prohibits discrimination on the basis of sex, concluded that sex was so intertwined with sexual orientation and gender identity that any discrimination based on sexual orientation or gender identity is necessarily, in part, discrimination based on sex. The The federal courts have decided cases involving transgender athletes' rights. In Hecox versus Little, 2 women sued the state of Idaho over its Fairness in Women's Sports Act. Jane Doe, a 17-year-old cisgender girl in high school, and Lindsay Hecox, a transgender woman in college. A federal court in Idaho reached the inescapable conclusion that the bill discriminates on the basis of transgender status and thus triggered heightened equal protection scrutiny under the Constitution. The court then issued a preliminary injunction against the anti-transgender ban, noting the absence of any empirical evidence that sex inequality or access to athletic opportunities are threatened by transgender women athletes, and instead finding compelling evidence that equality in sports is not jeopardized by Idaho's previous standard. The court concluded that Idaho had not identified a legitimate interest other than an invalid interest of excluding transgender women and girls from sports entirely. A number of states have enacted legislation that not only conflicts with federal guidance, but limits the rights of transgender athletes. This has not turned out well for them. K-12 schools, colleges, and universities need to be able to articulate policies that are compliant with federal law. The educational institution's policies may put it at the center of disagreements between its state and the federal government. The University of Iowa has already been forced to backpedal on its hasty decision to get rid of women's swimming and diving. After some female athletes sued, the university added back swimming and diving and also added women's wrestling to comply with Title IX. I do not recall Governor Reynolds nor legislative Republicans wading into the fight to protect girls' sports when all of this was happening. So I find this current bill not only legally risky, but petty, partisan, and hateful, and the reasoning shaky. Again, the courts are shaping these debates, and we would be taking a giant step off a cliff if we pass this bill. It will create years of confusion, lawsuits, but most of all, unnecessary discriminatory behavior toward a protected class of individuals. Vote no on Senate File 2342.